Hi guys, it's Kathy. I hope you're doing well. So I did sign a lease on a rental that I move into on the 16th of June. And what I've been told is internet is shaky there. So I have been told that from now until then to figure it out. Go satellite. See if I can go satellite and get a strong internet connection. But we'll figure it out. Don't worry. Don't worry. We'll figure it out. Probably won't stream the 19th or 20th. I don't know. I don't know yet. I'll tell you when we get closer. Maybe I won't miss any streams. I will set up some premieres if I can't make it though. Might go. Alright, we're going to finish this trial today. It's still sped up. I can slow it down if you want me to. Just let me know.
Joshua Fort?
Yes, ma'am.
When did you hear that?
On multiple occasions, but the last time was the last night that I left the house when I was trying to get out the back door, and Brandon had me pressed against it with a knife and told me that I was going to die, and so was Josh.
Okay. Now, are you aware, can you tell us what was Brandon's fixation on Josh Fort?
It started in the beginning, I think, as a business fascination because Brandon had all these businesses, and when he met him, he said that Josh was very knowledgeable and was going to help him with his businesses, and then quickly turned into, actually, you're sleeping with him, and this whole thing is y'all trying to get this business from me.
Now, did Brandon ever talk to you about trying to run over Joshua Fort?
Yes, ma'am.
Okay, when was that? Can you give us any kind of details about that?
I don't know. I don't recall the exact date, but probably several weeks before the shooting.
Okay. And that information came directly from Brandon himself, or was that from someone else? Or?
Directly from Brandon.
Okay. Did he ever talk to you about anything, any other kind of encounters with Josh Fort?
He told me that he had shot at a house there in Milan, that he thought Josh was inside. That was within the month before the shooting. And then there was one time, probably a couple years before the shooting, whenever Josh was living at the top of Pickerton Street, and I think he may have just moved there. And Brandon and one of his friends told me that they went in the house and held him up and asked him if he was sleeping with me.
Okay. Now, we've mentioned a little bit about firearms. Did you know Brandon to possess any firearms?
Yes, ma'am.
Okay, what firearms did you know him to possess?
I'm not good with the exact firearms, but I know there were several times he had pistols, and he also had some rifles.
Okay. And did you ever see him with those items?
Yes, ma'am.
When did you see him with those items?
There were a lot of times that he would put the pistols to me. There were several nights that I would wake up with the pistol beside my head. He rode down my mom's road at one point when I was living there, right before the shooting, with a rifle, just riding up and down my mom's road.
Now, do you recall speaking with law enforcement on the day of the shooting?
Yes, ma'am.
Okay. And let me back up. Do you recall how you learned about the shooting?
Yes, ma'am.
All right, can you tell us about that?
I had COVID and I was in the bed at my mom's, and Brandon's mom called me and said that she was
This is the hearsay.
Yes. So I'm sorry, I should have prefaced that by saying, don't tell me like what anybody told you specifically, just how you learned about it. So
okay.
Is it fair to say, based on what you just said, you got a call from his mother?
Yes, ma'am.
Okay. And did you take any actions after you got that call? Did you go anywhere?
My sister and we actually kind of thought Brandon might have done something to himself. So my sister took me up to town to see kind of where, because we thought it was in Brandon's parents' yard. They kind of live in the same facility. So we rode up there to check and see.
Okay. And did you see anything when you got there?
Yes, ma'am.
What did you see?
At the building where Joshua would work or live, I'm not really sure. I saw the body.
Okay. Was law enforcement there at that time?
I think there were a couple there.
Did Brandon call you after the shooting?
Yes.
Okay. Tell us about that.
Maybe I should rephrase that. He didn't call me. He had someone else call me.
And do you recall who that was?
His last name was Boone.
Okay. And what was the nature of that call?
He said that Brandon's truck was on fire and that he was trying to get in touch with me.
Okay. And did you take any action after you got that particular phone call?
I just told his mom and my mom, we were all standing there in the circle, or standing there, and I told them what they said.
Okay. At that time, how were you employed or were you working? Can you tell us a little bit about that situation?
I was doing clinicals, and I believe I was already working then at Dodge County Hospital.
And did you work at Dodge County Hospital after that?
Yes, ma'am.
How long did you work there?
I believe like 2.5 years.
Okay. Would you say that you were close with Brandon's parents during this time?
Yes, ma'am.
Now, you mentioned earlier that they didn't live far from this area, this shop here. I say here, the shop there on Mount Zion Street. Can you kind of give us some direction? Where was their house and what did it kind of look like compared to where that was at?
So they lived directly behind the gas station there in Milan, so like you could almost see their house from the place he was shot.
Okay. So the gas station you're mentioning, that's the Flash Foods or Circle K?
Right.
Which is, that's on Highway 280 and Main Street, is that correct?
I'm not good with street names, but I think
I'm
so.
also not good with street names, so that's okay. But you said the house was directly behind the gas station?
Yes, ma'am.
Was it in front of the railroad tracks or behind the railroad tracks?
Behind. If we're, from what, like literally in the backyard of the Circle K, his parents live. There's no street or anything between them.
Okay, what kind of house is it, structure-wise? What does it look like?
It's like a cement block. Used to be maybe like a shop or something. I'm not sure.
Okay. Now, you said earlier when you got this call from the Boones about Brandon wanting them to call you, you were with Brandon's parents, both of them, or just one?
Just his mom.
Okay. And Zion Street, when y'all drove up there after you heard about the shooting, did you know who the body was?
I knew from it being at the shop that it was likely Josh.
Okay. And what were your thoughts at that time?
I knew immediately that Brandon probably had shot him, and that my thoughts were Brandon was probably headed to shoot himself.
Now, did you talk to Brandon's mother at the time?
Yes, ma'am.
Okay. Did you talk to his father also?
No, ma'am, he was at work.
And I apologize if I already asked this. Had anyone seen him that morning, to your knowledge, Brandon?
Brandon's father.
Okay. And how did you know about that?
His father told me that he saw him that morning.
And I'm sorry, I don't want you to tell me.
Okay, sorry.
That would be getting into hearsay. So, anyways, we'll move on from that. Were you aware, were Brandon's parents, were they planning to move away from the area?
Not that I was aware of.
Okay. Did you ever try to poison Brandon?
Never.
Did you ever try to poison your dog?
Never.
Okay. Now, you testified earlier that it took some time after this incident for your divorce to be finalized from Brandon. Is that correct?
Yes, ma'am.
Okay. And so during the course of that time, while Brandon was at the jail, did you have multiple conversations with him?
I did, yes, ma'am.
In those conversations, did he ever admit to you that he shot Joshua Fort?
It's hard to recall. I think I've blocked a lot of things out, but I don't think so.
Okay. Did the two of you ever discuss, are you aware of an event that took place after his arrest at the Dodge County Hospital while you were at work?
I wasn't actually at work when the event took place, but I'm aware of the event.
Your Honor, I'm going to ask that she not be allowed to testify to.
Push your button there.
Sorry, Judge.
What's your objection?
That she has no foundation for what she's about to give.
Well, I don't know what the question is yet, but what's your response to that, Ms. Pitts?
Oh, my next question was just going to be if she ever talked with Brandon about that on the phone.
On the phone?
Yes.
Talk to the defendant on the phone? I'll allow that question, yeah.
Okay. Did you ever talk with Brandon about that incident?
Yes, ma'am.
Okay. And do you recall the particulars of that?
Yes, ma'am.
What did Brandon say?
That he was tired of the way the deputies were treating him, and that some of the nurses had cussed out the guards that were with him, and that he had, I don't remember how he worded it, but basically an event had taken place and they had tased him.
Okay. And was it your understanding that that event was a physical?
Your Honor, I'm going to object as leading.
I can rephrase.
All right, rephrase.
In your conversation with Brandon about that incident, what was your understanding about the event that took place, from what he said?
That there was some sort of physical altercation.
Between Brandon and who?
Brandon and one of the guards that were there.
Okay. Shortly after or before that event, did you also talk to Brandon about another physical incident at the jail?
Yes, ma'am.
Can you tell us about that conversation?
Brandon told me that he had gotten into an altercation with a guy named J.J. Williams at the jail, and that he had beaten him pretty bad, and they had put other charges on him, and that they were planning to move him to another facility.
Okay. Do you know Joseph Dooley?
Yes, ma'am.
How do you know him?
He was one of Brandon's friends.
Okay. Did Brandon ever accuse you of having a romantic relationship with Joseph Dooley?
Multiple times.
Okay. Did you have a romantic relationship with Joseph Dooley?
No, ma'am.
Did Brandon ever accuse you of having a romantic relationship with other people?
Multiple times.
That's all I have at this time.
Cross, Mr. Reed. Push the button, please.
Good afternoon, or morning, Ms. Blaylock. We've met before. I'm Sarah Riedel, and I represent Mr. Spires. During the time that after you and Mr. Spires had separated, and after he went to jail for this incident, you continued to talk to him on the phone for the next couple of years, correct?
For some time, yes.
And you put money on his books and all that sort of thing, correct?
Yes, ma'am.
Okay, now, you never gave these incidences to law enforcement about Brandon putting a gun to your head and a knife to your throat. You never told law enforcement about that in any interview that you had, did you?
Not in an interview, no, ma'am.
Okay. Now, the truck that Brandon had that day, he was having trouble with it, correct? It let you know that?
He had let me know that it was catching fire the morning before.
Okay, and that was actually the truck that he drove, correct?
Yes, ma'am.
It was in your name, but y'all were married at the time, correct?
Right, it was his truck. It was just in my name.
Okay, and you, I mean, it would have, you didn't make a claim to that truck other than the fact that for whatever reason during your marriage, y'all put it in your name.
Right.
Did you ever sign the title over to Brandon?
I think at some point I did sign the back of it.
So that's why he didn't have a phone with him. When the police found him, he didn't own a phone because he thought everybody was listening to him. He's not wrong.
And my vehicle was in his name and vice versa. And there was one point where we both signed the back of them to be transferred over.
Okay, so even though it was technically still registered to you, you had signed the title over to him?
Yes, ma'am. The truck was 100% his truck.
Okay, thank you. Now, your husband did suffer from some mental health issues, did he not?
Yes.
And he was on medication for these mental health issues?
Yes.
And you were aware that your ex-husband, Mr. Spires, talked to you about Josh Fort agging him on and making comments to him, were you not?
I was just aware of there always being issues between the two of them.
Okay. And Mr. Spires was afraid of Mr. Fort at times, was he not?
He was afraid that everyone was out to get him.
Specifically, he was afraid of Mr. Fort, correct?
I don't recall a time where he ever said, "I'm afraid of Mr. Fort," but...
Did his actions show that?
Yes.
Okay, now, as far as this incident about the bicycle, isn't it true that Mr. Spires, what he actually told you was that Josh Fort pulled in front of him at an intersection and that he wouldn't move? Do you recall that?
I don't recall the specifics of that conversation.
Do you recall anything about that, about where they were positioned and what happened?
I wasn't there. I just know that he told me that he chased him down with the truck.
Okay. I don't have anything further, thank you.
Redirect.
Was there a reason why you never told law enforcement in an interview, or let me back up. You said you never told law enforcement in an interview about any of these abusive claims about Mr. Spires. Did you ever tell law enforcement in some other way?
I called and made a report about a time that my tire was cut on a rental car at my mom's house. This was just a little bit before the shooting that I saw out the window was Brandon.
So you physically observed him doing this action?
Yes, ma'am.
And you called and reported that to Telford County?
Yes, ma'am.
Okay. You said earlier that Brandon was kind of afraid that everyone was out to get him.
Yes, ma'am.
In what ways did he manifest those beliefs? What kind of actions did he take?
He cut the cords on wires in our house because he thought that people were listening in. He told me there were times he slept up under the mobile home because he thought people were coming to kill him. He said he would not carry a phone because he thought people were listening in and were trying to take things from him. He always accused me of sleeping with law officials so that I could do these evil things to him. He was just constantly thinking that people were out to hurt him.
You know Sam Davidson, the sheriff?
Yes, ma'am.
Okay. Did you ever talk with him about any issues with Brandon?
Yes, ma'am.
What were the substance of those?
I contacted Sam because I knew he had a ministry at the jail to try and help me to get Brandon into a rehab. And he sent some people to talk to Brandon, and they took him to a facility that I believe was mental health and tried to help him get help there.
You said earlier, or Ms. Riedel asked you about him suffering from mental health issues. Did he also suffer from substance abuse issues?
Yes, ma'am.
Okay. And how long do you believe that was going on?
It was on and off the entirety of the time that we were married. He would be clean for a year or two, and then he'd relapse, and everything would be downhill, and then he'd get clean, and he was fine, and then he'd relapse again.
That's all I have.
Anything else, Ms. Freedom?
Nothing further.
May this witness be excused.
I would ask that she be excused from her subpoena.
Be excused?
Yes.
All right, Ms. Blaylock, you are excused. You are released from your subpoena, and you are free to go about your business. Thank you, ma'am. Who's your next witness, Ms. Pitts?
Your Honor, the state rests.
All right.
She can.
Yes, you are free to remain. Yes, you may. All right, Ms. Riedel, I presume you need some time with the court.
I do.
All right. You ready to make your motions now, Ms. Riedel?
Yes, Your Honor, I make a motion for directed verdict.
Push your button.
I'm sorry, I can never
Well,
remember
that's my
that.
job. I'm here to make sure we keep pointed in the right direction. All right, Ms. Riedel, you have the floor. You may proceed.
I make a motion for directed verdict, Your Honor.
That's it? All right, Ms. Pitts, a response?
I mean, I guess I'll assume that that's a motion for directed verdict as to all counts.
As to all counts, yeah. Well, let me go a little bit further on
Yeah,
that.
let's be a little more specific.
Yes,
on that.
I'm sorry, Your Honor. I do specifically, to all counts, but I want to specifically talk about the arson charge. I don't think that there's been any evidence that the car was set on fire purposely. I think the testimony from our last witness was that she had signed the vehicle over to him, so the elements of arson are not met at all.
Ms. Pitts?
Yes, Your Honor. So I just want to be clear, is your motion only as to the arson or is it to all accounts?
I'm going to make the motion to all accounts.
Okay.
All counts.
So I'm going to go through each and every one of them for the record. I would say that there is definitely, and I'll just group the first three together, malice murder, felony murder, and aggravated assault. There's been ample evidence in this courtroom through the witness box and the exhibits that we've seen that Mr. Spires, beyond a reasonable doubt, committed a murder. He shot this individual, a human being, Joshua Fort, with a firearm, with a rifle. He did so with intention. That there's certainly enough evidence before the triers of fact to make that determination, and did do that by shooting him with that rifle. And I'll just go ahead and address 5, 6, and 7. That same evidence that he had a firearm on his person when he committed the acts in 1, 2, and 3. And specifically as to count 4, I'm going to go a little bit more in detail. So this court heard from an expert witness, Mr. Terry Neal, that based on his training and experience working over 1,000 fires in his lifetime, some of those being arsons and intentionally set, that the extensive damage to the inside of the cab of this truck was indicative that this fire was intentionally set, and that a gas can was in the back of the truck, an accelerant used in that instance. I think it was also telling for the last witness that we had here this morning, Ms. Blaylock now, that Mr. Spires called her the night before and claimed that his truck was on fire, indicating certainly an inference that can be made by this jury that setting his truck on fire was something he'd already been thinking about. The photographs of the truck itself, I believe, are enough to suggest arson in this case. If you look at the cab of that truck, there's not a stitch of the seat left, none. The truck was burned so extensively in the back that the tag couldn't even be read. The tag was melted off of the truck. The areas where this truck was burnt certainly indicate that this was not some mechanical or electrical fire, and there's certainly enough evidence for this jury to make that inference from what they've heard in this case. As to the ownership of the truck, Ms. Spires clearly, or Ms. Blaylock, excuse me, clearly stated that this truck was titled in her name.
Wait, back up. Well, she did say that. Her name was on the title. She did say that. All right, go ahead.
At some point, but we don't know what point, she signed the back over to Brandon. That's not been here. So there's evidence before this jury that this truck was titled in her name. In addition, when Agent Ballard was on the stand, I asked him, during your interview with her, did she say this truck was titled in her name? He said yes. Did she have insurance on this vehicle? Yes, she did. She said that during her interview with Agent Ballard. So there is sufficient evidence in this case. If you want to say they jointly own the property, that may be so. But she at least has some ownership interest in this truck. It's titled in her name. The tag would have been in her name. The insurance would be in her name. And so there's ample evidence for this jury to make the determination, whether they want to or not, that the truck belonged to him and that he intentionally set it on fire in this case.
Well, she also said it was 100% his, being the defendant.
Just so you know, it does not matter one bit whether they keep the arson charge or get rid of the arson charge. Doesn't matter.
Right. Well, Judge, I'll just put it like this. When it comes to possession of an item, right, possession is 9/10 of the law. Everybody says that. That's a common phrase. I'm sure she doesn't want that truck to be hers, right? It's just been involved in a crime, that kind of thing. But under the law, technically, it is her truck if it's in her name. It's titled to her.
Well,
and so,
before you stand up, Ms. Reed, I'm going to ask Ms. Pitt's question. I'm going to ask you a question. And I'm glad we have a law student here with us today to correct me when every inch of my
There you go, Donald. Law students.
experience is telling me not to ask this next question, but because I don't know the answer. All right, so is it possible in Georgia to commit arson of your own property?
sure, and Judge, there is a provision in the arson statute that provides that if a vehicle is insured, you can't just go set your own vehicle on fire. If I went out there right now and set my vehicle
But what
on
if I
fire,
pay the insurance company off?
if you paid them off, well, that would be insurance fraud.
Well, I didn't mean to commit fraud, but to not make a claim and I just pay the loan off or whatever it is. Is that arson?
If you paid it off before you set the vehicle on fire, possibly.
Oh, well.
If you waited until after, no, I don't think you could do that, because at the time that the fire was set, a bank or some lien holder had a security interest in that vehicle. And so arson falls, all of that falls under arson. And so I think at the worst in this case, the truck was jointly owned by two people. They had not been divorced yet. I'm sure when their divorce was going to be finalized, this truck would have been his. But in this courtroom, we don't work on what would have been. We work on what was. And what was at the time was that this vehicle was titled in her name. She testified to that. She gave that information in her interview. And so under the law, it legally is her vehicle.
Ms. Riddle, your turn.
Okay, Your Honor, first of all, There is no evidence whatsoever that there was anything owed on this truck. Nothing, no evidence whatsoever. There's no evidence whatsoever that any insurance claim was made. There's no evidence whatsoever that. The element of arson is lack of consent, and the act must occur without the consent of the relevant parties, such as the owner, insurer, or other parties with a security interest in the party, well, in the vehicle. Well, no insurance claim was ever made on this vehicle, none. She said this vehicle was 100% his. It is obvious that she didn't sign the title over after it was burned up because the vehicle was done. I mean, it wasn't a usable vehicle at that time. They were married. This was his truck. She said it was his truck. There was never a claim made for insurance. There was never any thought of any claim being made for insurance. They tried to kind of skirt around this and said he was burning up evidence. There wasn't any evidence in the truck. There's just not, arson is not here in this claim, in this case.
All right, the court is going to deny the motion for directed verdict to counts 1, 2, 3, 5, 6, and 7. On count 4, there's evidence to go both ways, and I think Ms. Pitt said it. There's enough, I think the jury could find either way. But I'm going to reserve ruling on count 4 until later in the proceedings. So, all right, that's my ruling. And we'll take a break ourselves in just a moment. And the state has now rested. So, Ms. Riedel, are you prepared to go right into a defense, if any?
Judge, I am really not.
Push the button.
I am really not. When I'd spoken with Ms. Pitts, and I should know better than this, but usually when we say it's going to be after lunch, or it'll be lunch when we get done, I think, well, it's going to be later than that. But first of all, I have not talked to I had told my witnesses that I would need them after lunch. I have not had an opportunity to go over with Mr. Spires the constitutional rights, and I think we do need to deal with that.
You know where I'm going, so here's what we're going to do. We'll take a 10-minute break ourselves, and then we're going to come back in on the record, and before we take another step, I want you to have, you know what I'm going to ask you to do, have the conversation with Mr. Spires about his constitutional rights, and then I'm going to get on the record my colloquy with him about his defense, and then we'll see where we are.
Yes, sir.
All right, so we'll be back in 10 minutes. Thank you all.
Yes, sir.
Right, with the agreement of counsel, I will write on here that is permissible. I guess, how do we get that to her? Allow him to step out there and tell her?
Or have,
You have any idea?
if they can fit him back in the truck.
Okay, I'll have Miss Mildred just figure out what vehicle it is. All right, I'm going to read this into the record just so we're all clear. I have a note from, golly, I wish I could read it. I can't read which juror it is, but it says, I have my lady sitting outside in the truck. I didn't know if she could be in the courthouse or not. I was asking, could she come in and get out of the hot truck? And with agreement of counsel, I'm going to write on here, yes, that is permissible. And the bailiff will get the necessary information to go out here and find her. Is that acceptable, Ms. Pitts?
Yes, Your Honor.
Or any objection, Ms. Pitts?
No objection.
Any objection, Ms. Riedel?
No objection.
All right, very well. All right, with that, we are in recess. Thank you all. Before we bring the jury in, there's Mr. Spires. The issue with the juror and his girlfriend out in the truck, I understand another relative appeared and took her. So that issue is, I'm sorry, be seated, is moot at this point.
Okay.
And I don't know that the juror has been told that any objection to telling that when he comes out of the jury room. Okay, will you tell Ms.
Objection on the part of the state.
Okay, tell Ms. Mildred to tell him that she's taken care of, but we ready to proceed? Let's see, we got
I don't know, that sounds like a mistrial to me.
Haley, everybody's here. Mr. Spires is here. Let me find my right spot here. Now you're not bringing the jury in, are we? No, don't bring them in. All right, very good. All right, we have all of our parties and players here. We're back on the record. Ms. Riedel, have you had the opportunity to speak to Mr. Spires about his decision to whether to testify or not?
I have, Your Honor.
And before we do, before I get into this, and before you call your first witness, is Mr. Spires prepared for the colloquy between himself and the court?
He is, Your Honor. His decision at this point, at this moment, is not to testify, but I would prefer the court still
Oh, absolutely.
go
I'm
through colloquy.
going to get it on the record. All right, Mr. Spires, this is one of the few times in this process that you and I will get to speak directly to one another. We've reached the posture in the trial where the state has now rested, and Ms. Riedel has indicated that you have decided you do not wish to testify. I have some questions to go over with you about that.
Yes, sir, Your Honor.
And there's no hurry, no rush, so I just want to make sure you understand all of your rights. Pull that microphone down just a little bit.
Yes, sir, Your Honor.
All right, Mr. Spires, do you understand that you have a right to testify, and if you want to testify, then no one can prevent you from doing so? Do you understand that?
Yes, sir, Your Honor.
Do you understand that no one can make you or compel you to testify? That is, do you understand that you also have the right to not testify if you do not want to? Do you understand that?
Yes, sir, Your Honor.
Do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not? Do you understand that?
Yes, sir, Your Honor.
Do you understand if you do not testify, then upon proper request by you and your attorney, the court will instruct the jury that your decision cannot be used against you? Do you understand that?
Yes, sir, Your Honor.
Do you understand that if you choose to testify, you will be both examined by your attorney, Ms. Riedel, your lawyer, and then you will be cross-examined by the assistant district attorney? Do you understand that?
Yes, sir, Your Honor.
Do you personally want to testify or not?
No, sir, Your Honor. I don't believe in testifying in court of law.
All right, just to make it finally clear, you are declining to testify. Is that correct, Mr. Spires?
That's right, Your Honor.
I don't believe in testifying in a court of law. I ain't testifying in a court of law. I'm going to tell everybody in the jail what I think, but not in a court of law.
Very well. The court finds that Mr. Spires has decided to not testify with a complete understanding of his rights, and so noted for the record. Now, Ms. Riedel, are you prepared with your defense, such as it may be, or will there be one, or what's your next step?
Your Honor, I think that the
Did he just ask her if she's even going to try? Are you going to try? Are you going to say anything? There's really nothing more to say. We saw all the evidence.
defense is not going to call any witnesses, so
All right.
we are not going to present the defense,
So the defense rests?
Your Honor.
All right. Well, then, apparently, the next item of business should be to do the charge conference. And I will just state that I've been working on it with Ms. Stanley, Ms. Stanley. And I have you got my copy printed out? Can you make a couple of extra copies?
Yes, sir.
Okay. And of course,
I'll give
as
him a place to
you
testify.
probably all know, I mean, we're going to have all the pattern charges. And on the motion for directed verdict on the arson count 4, if I haven't said it already, I'm going to reserve ruling on that. And now that the defense has rest, I will let it go to the jury, but your objection will be noted, Ms. Riedel. So I'm going to, of course, give all the preliminary charges, all the standard charges, and then the pattern charges on these counts 1 through 7. Do you have anything else specific that you can think of before we get into anything on the record about additional charges or pattern charges?
The state only intends to request pattern charges, so
Okay.
don't have anything to offer.
Well, Your Honor, obviously would want to go over all the charges, all the pattern charges that you intend. We would only request pattern charges, but I want to make sure that all of the pattern charges that we want are at least considered by the court.
Oh, absolutely. Do you know, other than the 7 for the charges, do you have anything specific that you want me to start working on?
Well, the lesser included charges.
Oh, okay, hold on. That's what I'm getting at.
Let's see, let me see my, okay. I have prepared charges, and I'm sure most of them are what you have. This is the full list. Does this include, Anthony, does this include what we did last night?
Yeah, that full package.
Okay.
If you want to give it to me. Here's a copy for him.
His that person that filled that. Do we have a copy for them?
Yeah.
Is that a full copy?
Yes.
It doesn't look very big. Is it?
It's front and back.
Okay. I was gonna say.
So they had no defense at all to anything. So why exactly did we go to trial, I wonder?
That's a full copy,
It's a full copy.
including the one we did.
This hasn't been stated, but
Okay, thank you.
right.
Okay. Yeah, I got you. Yeah, we'll have time. Okay, Ms. Riedel, you indicated you have some additional charges other than just for the indicted charges.
Yes, sir.
Go ahead.
Okay.
And I'm sorry, are we doing the charge conference now?
Well, were you ready to do it now, or I'll just get a heads
I
up?
would like the opportunity to look over the ones that she's requested.
Okay, well,
And I do believe we need to have Ms. Riedel rest in front of the jury.
Yes, and then, Your Honor, I would ask for some time for
yeah,
lunch.
well, let's do this. Hey, I expected,
Yeah, I understand.
you said this was going quicker than you expected. I wasn't expecting that as either. So I have been a bit scrambling on how to proceed with this. All right, so here's what we're going to do then. I'll bring the jury back in just a moment. I ask you if you rest, and then I will just excuse them until 1 o'clock, and then, will that be enough time?
Could we do 1:30?
On me, 1:30?
Or we'll do the charge conference during that time, right?
Correct.
Okay. I would ask for 1:30.
All right, well, let's do that. All right, bring them in.
Charge conference is in the good over all.
That was the jury trial.
Charge.
The jury has to, yeah, the jury. I don't know. I feel that since they didn't even put on a defense at all, the jury sort of has no options left. They're going to find him guilty.
All right, please be seated. We have everyone in place. We have all of our jurors in place. We have a properly constituted court, and we are now back on the record. Ladies and gentlemen of the jury, we have completed some of the things that we needed to do here. Just to refresh our status in the case here, the state has now rested its case in chief. And Ms. Riedel, what says the defense?
Your Honor, the defense rests. We are not calling witnesses.
All right, very good. The defense has now rested, so the evidentiary portion of the case is now closed, ladies and gentlemen. We have some more business to do, so I'm going to give you all a nice long lunch break here. Please be mindful of all of the restrictions that I've given you before. Don't discuss the case with anyone. Don't allow anyone to discuss the case with anyone in your presence. If anyone has done that or does do that during the break, I want you to make sure you notify one of the bailiffs or the deputies and let me know, and I will take the appropriate action. And with that, I am going to send you on your lunch break and be back here in the jury room at 1:30. All right, very good. Thank you all.
The jury's not deliberating yet, but I will tell you, spoiler alert, they deliberated for minutes, not hours, not days, not months, not weeks, not years, minutes. We do get to hear from the defendant soon. I don't know, soon is relative, but we will get to hear from the defendant.
All right, you close that door for me. All right, please be seated. Thank you all.
Do you often measure in seconds, Bren? I'm asking for a friend. I need to know.
All right, please be seated. Oh, one more. Be seated, please. Ladies and gentlemen of the jury, first of all, I want to thank you for your promptness here, and I know you've been back there in the jury room for a good bit longer than I anticipated. That is completely and entirely my fault. Everything took longer to get done than I hoped it would take, and please, if you want to hold someone responsible for that, please hold me. We're doing the best we can to move through. As I indicated a few moments ago,
Judge has to say that because they were back there too long. They could like hold it against these lawyers and get pissed off at the lawyers. The judge has to be, whoa, my fault, guys.
Before the break, that both parties have now rested, and the next step in the process, as I told you at the very beginning, was for the attorneys to give what is called their closing argument or summations of the case, and that will take place now. Ms. Riedel, are you ready to proceed?
I am, Your Honor.
You may.
Thank you. I need a little bit bigger spot here. Good afternoon, ladies and gentlemen of the jury. I appreciate y'all's time. Y'all have had 3 long days here with us, and I know you're ready to be done, but we just got a little bit more to do, and I appreciate the attentiveness that you have given us. I want to start by going over, just summarizing the evidence that we've heard over the last couple of days, and kind of go over what each of our witnesses have said. And I'm going to put it in a nutshell because it's taken us 3 days to get there. I'm not going to be here that long. But our first witness was Melissa Scott, who was the mother of the alleged victim in this case, Joshua Fort. She stated that Mr. Fort had struggled with alcohol and drugs for some time, especially since he had been in Milan. And you saw she gave us pictures of him. And unfortunately, the pictures that we had are kind of older pictures, but he had struggled with drugs and alcohol, and she had stated that she had to just teach him with tough love because of the problems that he had gotten himself into. And she told us about an incident.
Hi, Cloud. How are you?
That her son had told her about when she first met Brandon Spires, and she said that he came in and made some comment about something that, about being with his wife, and then he said that they just started laughing and then just had a conversation. He came in and spent time with them. And that was pretty much the extent of her testimony. And then Brandon Merritt came in, and he was working with the Telfair County Sheriff's Department at the time of this, and he was the first person on the scene. He said he got there and there were shell casings all over, and I think he pretty much said that he probably did run over them. And if you recall, he said that the street was a normal sized street, just a normal city street, and he also stated that the building that was kind of adjacent was partially blocking the post office. And then we have Miss Jane Williams, who is our sort of eyewitness to this case. And I think what she had to say was really important. What she stated was she saw my client about in the middle of the road. And she said when she saw him, he was fixing something on the back of his truck. She didn't know what he was doing, but he was messing on the back of his truck, fixing something. And then before she passed him, he went back to his truck and he sat down in the driver's seat. And then she passed by and they waved at each other. Now, that doesn't sound like somebody that came there to hurt somebody, to kill somebody. It's the middle of the afternoon, 12 o'clock, 12:30, between 12:30 and 1, I think Miss Williams said. And he was there, he fixed something on the back of his truck, he was getting back in his car. And she said then it took her about 2 minutes to get to the post office. And then she said in that 2 minutes, after she got out of her car at the post office, she heard some shots. And she didn't think much about it. She saw him, but she didn't think much about it. She just thought maybe he was shooting at, some animals or something. Our next witness was Cam Boone, and she's the one that initially saw Brandon Spires after this incident occurred. She saw him walking on her road where she lived. Connect Road, I believe is what she said. And she said that Mr. Spires was and later she went to the scene where his vehicle was. She said he was about 5 or 6 miles from his vehicle. And she said he told her his name, and he asked her to call his wife or mom. I don't think she could remember who it was she called, but she got in touch with somebody. And what she said was, he said that his vehicle, he had a wreck and his vehicle caught on fire. And she said that he looked a bit disheveled. And then Tom Boone, her husband, came and testified. And he also said that the truck was in the ditch and it was on fire. That's what he said. And he said that he talked to Brandon, and Brandon gave him his name. He said his name was Brandon Spires. And then we have Terry Neal, who was the volunteer fireman. Now, he had been a volunteer fireman for 27 years, but he had no formal training or no real training at all in, he said that his purview was not to determine how fires were set.
He's the mayor, so what he says he knows. So, fine. Hi, Debbie.
What he said. He said he didn't test for any accelerants. He said that he just thought that it was purposely set. And he said he used his experience for that, but he said it was because it said that the cab was so burned up, and it should have been burned up more up under the hood if that were the case. Well, we know from the pictures that you've seen, up under the hood was pretty much destroyed. That was testified to, and I believe that it was testified that the hood, up under the hood and in the cab was both destroyed they were both burnt up, about the same. And then we had Mr. Rothwell, or Deputy Rothwell, he was at the Telfair County Sheriff's Department, and he saw Brandon Spires walking, and he said that he was probably about 15 miles away from downtown Milan where this incident occurred. And Brandon told him that he didn't call anybody because he didn't have a phone. And he said that he had wrecked his truck and it caught on fire, and then he left and walked to try to find somebody. And we know that when he found somebody, he did stop her and ask her to call and gave him his name and told him what had happened. And then we have from Deputy Josh Spires, who next came in and talked to us. And he said that at that time he was working for the Telfair County Sheriff's Department. And he said that when he arrived on the scene, he saw a male subject who was on the ground, lying on the ground, and was unresponsive. And then he went and saw Brandon, and he said Brandon was on the side of the highway, and he said that and Brandon had told him that his truck caught fire, and he didn't have a phone, so he couldn't call.
What the heck is going on? What is she doing? Why is she doing this? She's his defense attorney. She's summarizing all of the crimes in order and the people who said that they were crimes.
Call anybody. And he said that Brandon appeared flustered and scared. Next, we heard from Donna Owens. And Donna Owens was the girlfriend of Joshua Fort. And she stated that she was aware of no one that wished any harm on Joshua. But she did tell us that she had this gut feeling that Brandon Spires had done it. She said that there were some altercations between the two of them, and she said that she did mention a time where she thought she saw Brandon. It was at night, but she didn't see. She heard some shots, but she didn't ever see him shooting. Then she said she saw Brandon on Christmas Day. Now, Christmas Day was just 3 days before this incident occurred. And she said that Brandon came up and saw Josh at his little building there. And she said that they just spoke, and that was it. There wasn't any kind of altercation or fighting or fussing then. And she said she was unaware of any other incidences between Brandon and Josh involving a firearm. She didn't know anything about any firearms. Then we had Agent Beth Cootie who testified. She's with the GBI, and she was the blood-stained...
Now, listen again, I'm going to say it again because some people are here today that weren't here yesterday. I'm going to put the full trial in the members-only area if you want to listen to the GBIs, but I cut them all out because every single one of them was boring, really boring. And Terry Ham, did you change your icon, or am I just blind?
The bloodstain pattern analyst and also the crime scene analyst. Now, she had that picture that y'all saw up on the screens there that had all the little markings where all the casings were located. And she said that she also assisted in the search for the firearm in Milan. I don't think she knew exactly how they knew where the firearm was, but we found out later that Mr. Spires told them where the firearm was. And they did indeed find it right where he said it was going to be. And she stated that casings can be easily moved around if people are driving around them. And she said when he was shot, she would have no knowledge about where Mr. Fort was when he was shot. In other words, was he standing here and moved over there? Or she said that she could not tell where it was that he was initially shot. Our next witness was Dr. Michelle DeMarco, and she was the medical examiner from the GBI. And she gave us a lot of information on where he was shot and gave us a lot of information regarding that. And of course,
I really like the cartoon. I really like it. It looks nice.
Of course, determined that the manner of death was due to the gunshot wounds. But she said that she could not determine how far away the gun was from Mr. Fort when Mr. Fort was shot. In other words, was it 6 feet away? Was it 10 feet away? 12 feet? She said she had no way of knowing. And she also stated that she had no idea where he was shot first. And then we had Mason Cree, who was the ballistics expert, and basically what he said was that the bullets came from this firearm that Brandon Spires owned, which Brandon had already said that was the case. Our next witness was Skylar Reese, and he is the gentleman who stated that that he had gotten the footage from the surrounding businesses, and it showed Mr. Spires leaving the scene of the accident, of the incident, and going up Mount Zion, turn to the left, turn back to the left, and you ended back up on Mount Zion Street, and then headed on out, and we can presume that he headed on out to where he put the gun. But he's the one that told us all about that. And then we had Joshua Ballard who spoke, Special Agent Ballard, and he said that that the firearm was recovered from Charles Dooley's property, that he had interviewed Brandon twice, and that Brandon had he had first of all asked for an attorney, and then he had asked to see him again. After he was served with the arrest warrants, he asked to see him again and to talk to him. And at that point, he told him exactly what happened. He said that he was scared for his life. He said that Josh had threatened him several times. He said that he was scary to him, that he had guns before, that he had threatened his life several times. And I'm using a quote here. He said he beat my ass the day before. And he said that he had bruises on him. We don't see his body at all. We only see a picture that was kind of like, I guess it was sort of like the mugshot that was taken that day, but we don't see in the rest of his body. But he said that, Brandon said that after this incident happened, he was scared and he rode the dirt roads for a minute. He threw the gun out, he freaked out, and he wrecked. He said he had to defend himself because of years of dealing with Josh. He said that he was kind of all over the place. And as we see in this, at this point in time, the law enforcement that was interviewing him were concerned that maybe he had used some drugs or something was wrong, because as you could tell at this point in time, he was all over the place, saying crazy things, was being just saying all sorts of stuff. Now, Brandon said that he needed his medicine. That's what he said. I need my medicine. And we know that he does have mental health problems and that he took mental health medication. But he did deny, Mr. Spires, Brandon did deny that he was using drugs, although the law enforcement was very concerned for him, and they were concerned because they were afraid of what might happen once he gets into jail if he didn't have any kind of attention, if he had drugs in his system. But to go on, he said Mr. Spires did say things. He did say that the car was in the ditch, and that Mr. Fort reached in his pocket, came toward him saying all kinds of things. He reached in his pocket and it scared him to death. He thought that he was going to have a gun, and that he knew that Joshua Fort had guns, and he was scared to death of him. He said when Joshua Fort reached in his pocket, he thought that he was going for a gun. Mr. Ballard, or Special Agent Ballard, also in talking about the arson, he admitted that there's no evidence, there's no forensic evidence that this vehicle was purposely set on fire. We have one volunteer fireman with no expertise in the field of how a fire is started. He said he had no experience or did not even check for accelerants. So there was no forensic evidence of that. He said that he spoke to Lynn Spires, who testified next, and he said that Miss Spires at the time said that was the vehicle that Brandon always drove. Now, Special Agent Ballard admitted that he did not know where the fire started. He couldn't say that. He said there was significant damage under the hood and in the cab of the car. He stated that the testimony was that Brandon was, and I'm kind of going all over the place, but this is the testimony and how...
No, that's not what he said. He said the fire was started in the passenger seat, in the front passenger seat.
It was given.
Which is a weird place for a fire to start in a car.
That at the time of this incident, Brandon was parked somewhere in the middle of the road, and the casings were in the middle of the road, and that he did say that he thought that if the casings had been run over, they would be smashed. But our first officer, the first responder on the scene, said that he thought that he had hit some of them. So I don't know. But our next and last witness was Lynn Blaylock, who was the former wife of Brandon Spires. Now, she said that she did not know Joshua Fort, even though her husband had accused her of being with her, seeing her, but she did know of the difficulties between Fort and her husband. She told us numerous things that her husband allegedly did to her, but then she did admit that she had continued to talk to him for 2 years after he was locked up, put money on his books. And she also stated that she had never told law enforcement about this, or she did not tell law enforcement about any of these incidences when she met with them for the first interview. Now, importantly for the arson charge, she stated that Brandon had told her previously the night before that he was having some problems with the vehicle. He also told her, or she also told us that it was his truck. It was just in my name. That she had no claim to the truck. She had signed the title over to him, and her words were, it was 100% his truck. She stated that he had mental health issues and that there were always issues between he and Fort, and that her ex-husband, Mr. Spires' actions showed that he was afraid of.
I like it much better when I'm annoyed at the defense attorney for like lying or saying the facts wrong. This woman, I don't even know what this woman is doing right now.
Mr. Fort.
True,
Now that's
yeah.
kind of what each of our witnesses said, and I put it in a nutshell because we did that in about 10 minutes, what it took 2 days to do. But I want to go over the law just a little bit. And again, I am not going to give you all the charges by any means, because in just a few minutes, this Judge Johnson, is going to read all of the law to you. And honestly, I mean, I'm graduated from law school, and it's hard for me to hear it and comprehend it all at one time. But the main thing that I really want you to understand and Judge Johnson's going to instruct you on this, is that Mr. Spires, his choice not to testify can in no way be used against him. He doesn't have to present any evidence. The burden of proof is solely on the state. And another thing that I think is very important is that intent is an essential element in any crime, and it must be proved by the state beyond a reasonable doubt. There's no presumption of criminal intent. He will not be presumed to have acted with criminal intent. But you can.
We don't need to presume it. He said it. He said, I'm gonna kill that guy, and then that guy's dead.
Obviously, as a jury, that's your job to decide whether or not he had criminal intent. Now, he's been charged with several things, and I know y'all have heard all of the charges, and I'm definitely not going to go over the elements of these charges because the judge is going to read them to you. But they are malice murder and felony murder, aggravated assault, arson, possession of a firearm during the commission of a crime, and it's 3 of those charges, but it's during the commission of the crime of felony murder, during the commission of the crime of malice murder, and during the commission of the crime of aggravated assault. So that's why there's 3 separate charges that are the same charge. Again, if my client acted in self-defense, that is an absolute defense to that. Now,
Self-defense to the truck too. The truck was looking at me weird, so I set it on fire. Self-defense. She hasn't said those 2 words this whole trial.
The charge of arson is to deprive the owner of this vehicle. She purposely set it on fire to deprive the owner of the vehicle. Now, Miss Blaylock has said it was his vehicle. It was in her name, but that she had signed the title over. She didn't remember exactly when she signed the title over, but let's think about this. You wouldn't sign the title of a vehicle that's burned to smithereens. They were going through a divorce, and it is likely that the title was signed over prior to this incident happening. And she said it is 100% his vehicle. and there's going to be a charge that you're going to hear that in arson, there is a presumption that it's an accidental cause. And the judge will read over that to you, read over all that charge with you. Now, as it goes to murder and to malice murder and felony murder, there is something that's called a lesser included offense. And that lesser included offense, and you're going to be charged on it. So again, I'm not going to read it all to you, but that lesser included offense is called voluntary manslaughter. And the judge will read that to you, read that charge to you. If you are justified.
Martha, thank you for the highlighted message on Twitch. Goat. I appreciate it. Thank you.
The fact that a person's conduct is justified is an offense to any, to this action, to either murder, malice murder, felony murder, aggravated assault, or any of the three, possession of a firearm during the commission of a crime. A person does not have a duty to retreat. You may be thinking, well, why didn't Mr. Spires just get in his car and leave when Mr. Fort was walking out toward him, shouting, making noise, and put his hand in his pocket? Why didn't he just jump in his car and leave? Well, you got to remember that this is a split-second decision that somebody has to make. You don't have time to think about what should I do, so it's a split-second decision, and you don't have a duty to retreat. In other words, you don't have to leave. If somebody comes at you with what you believe to be deadly force, you do not have to retreat. Now, I know you have heard a lot, and we talked about a lot, even in opening statements, we talked a lot about the burden of proof. But the biggest thing to remember is that burden of proof is always on the state. That burden never switches to Mr. Spires. They have to prove that beyond a reasonable doubt that Mr. Spires is guilty of each of the defense of the charges. Mr. Spires doesn't have to prove a single thing. The state, even after invoking that this was self-defense, the burden doesn't switch to him to prove that it was self-defense. The burden still stays with the state to prove beyond a reasonable doubt that it was not self-defense. Now, we talked about the levels of proof, and I'm not going to go over them quite as much as I did in opening statement, but you've got the lowest level, that's probable cause, and that's what it took in order for them, for the law enforcement to swear out warrants against Mr. Spires. And then you have a preponderance of the evidence, and that's like, when I told you the scales of justice, they just kind of tip a little bit, just more likely than not. And then there's the clear and convincing evidence, or clear and convincing proof, and that is the kind of proof that it takes for the government to take your children away from you. So it's a pretty strong level of proof. It's a pretty high level of proof, but beyond a reasonable doubt is even higher than that. The scales of justice tip all the way down, and the beyond a reasonable doubt. The government has to prove each element of each crime beyond a reasonable doubt. That's each of the crimes. Well, you might say, well, maybe I think he might have done this, or yeah, it's more likely than not he did. That's not the level of proof that you have to have. It has to be beyond a reasonable doubt. And so I think that there is doubt in this case. Now, there's no doubt that Mr. Spires shot Mr. Fort. He came in here telling you that from the very get-go. He might not have ever even been able to have been prosecuted had he not been honest and said, this is what happened. They would have never found that gun. They might not have ever figured it out. But he came up and he said, you know what, I did it. I was scared to death of this man, and I did it. Now, his actions you have to consider, was his actions what a reasonable person would do in his circumstance? Now, obviously, it's not reasonable for you to fire upon an unarmed man. That wouldn't be reasonable, but what if you thought that he reached in his pocket to grab a gun? Now, you know your difficulties with him previously. You know that he's had guns in the past, and he reaches down and he's shouting all kinds of crazy stuff to you, and you are terrified. You're sitting out there in the middle of the road because you got up to see about him, to see what he wanted, He called out to my client. He got up to see about him, and when he did, that's when he puts his hand in his pocket. Now, is that reasonable? It's hard to know what you would do in that situation, but what would a reasonable person do? That is what we have to determine when he thought that Mr. Fort was grabbing for a gun. My client is not guilty of any of these charges, and I'm going to take the arson out of it for a minute. He is not guilty of any of the other charges, because if he did this in self-defense, then the crime wasn't committed. That is an absolute, that is a defense to any of those charges, is self-defense. And that's what he claims. Now, we've heard all the law, and we've already talked about that, and you're gonna hear the judge go over all of it. And just keep in mind what was in Mr. Spires' mind at the time. What was he believing? What would a reasonable person believe at that time? I would ask that after looking at all of the evidence, and after seeing everything that you've seen, and after understanding the way that he felt that his life was in danger, that you would come back or not guilty on all of those charges. Now, the charge of arson, his ex-wife has already said it was 100% his car, his truck, 100%. It was in my name, but I signed it over to him. He wasn't trying to deprive her of her vehicle. First of all, we have to presume that this was an accident. The car was in the ditch, it was on fire, the motor part, that part was burned up under the hood, and the cab was burned up. We have to presume that that was an accident. But even if you don't believe that, then you go back and...
I love Tupperware. I do. And I'm so glad no one around me sells Tupperware, or I would be broke.
You say, well, was he trying to deprive Miss Spires of that vehicle? She says, no, it was not her vehicle. It was in her name, but it was his, 100% his. So I would ask for you to come back as not guilty on those charges as well. Thank you.
Thank you, Ms. Reed. Ms. Pitts, you may proceed.
Yes, sir. And I am going to use a PowerPoint.
Ms. Miller, is the jury monitor on? I can't see.
It is.
Okay, very good. Thank you.
And I don't profess to be great with technology, so I'm going to attempt to do this. Good afternoon. I want to, kind of echo some of what Ms. Riedel said. We do thank you for...
You gotta go to the party. You gotta go to the Tupperware party.
Being here, like I said in opening, this process does not work without you here. That is the great thing about our country. I know politics can get really dirty. We've just gone through an election cycle, right? Everybody's tired of getting the mailers. Everybody's tired of seeing the ads. But one great thing about our country is the judicial system. And it's the defendant's right to have a fair trial by a jury of his peers. And that is the great thing about our country. Not every country has that. And so just as important as it is to go and vote in elections, it's also really important to serve in a jury. I personally had to serve in a jury recently myself, so I feel your pain from having to sit here and listen to everything, but we do appreciate your service. So I'm going to attempt to use my technology. Okay. And so this slide is just a quote. Murder is the unique crime. It's the only one for which we can never make reparation for the victim. A murder is the most serious crime a person can commit. And why is that? Because there is not one thing we can ever do to bring that victim back. And that is just the unfortunate reality of the situation. Joshua Fort, this was State's Exhibit 1. We started off this trial with this. This man did not deserve what happened to him. And his life is important in this case. His life and the loss of it is why we're here. So I know Ms. Riedel just went through every single witness that we talked about in this trial. I'm not going to do that, but I'm going to talk to you a little bit about it. You saw 119 exhibits in this case. That's how many that we presented to you. Those included videos, photos, and physical items from the crime scene there on Mount Zion Street in Milan, as well as from that well on the property off Highway 165 that belonged to Mr. Spires' friend, Joseph Dooley. We also have the murder weapon. We have the .22 rifle, states 80 down here. I'll get that out in a minute. You've got the recorded interviews of Brandon Spires that we played. You've got the 911 dispatch. I know that was probably sometimes difficult to hear and understand what all those 10 codes mean. I still don't know what 10 codes are. I've been working in this line of work for 10 plus years, and I still don't know what they mean. I listen and try to put it together. We saw that surveillance footage from Thunderbird Oil and Hewlett's Body Shop. And that was important because it gives us a timeline. Though the footage from that surveillance put Brandon Spires' truck leaving the area of the crime scene around 12:57, pretty close to 1 o'clock. And so we know from the 911 calls that within 30 minutes or so, we've got our first 911 call about a man bleeding profusely on Mount Zion Street. And we also know from that dispatch that around 2:15, we've got the first call from Mr. Terry Neal, Jacksonville Fire, that there is a truck burned up in Jacksonville. So that the 911 dispatch and the surveillance kind of give us our timeline. You also saw the autopsy photos. I'm sorry that you had to see those. They're necessary. They show each and every single one of the gunshot wounds, entry and exit. Why are those important? We'll get to that in a minute, but there was a reason and a purpose for sure.
My Tupperware is used basically to grow interesting things. Yes.
Showing you those photographs. We also had the fragments that were recovered from the body. You had the contents of Joshua Fort's pockets. What were those contents? Certainly not a firearm, no weapon, pack of cigarettes, a keychain, and we know from the autopsy there was also a lighter in there.
I can't remember what the lingerie parties were called though, Monica. I'm trying to. So there was Tasteful Treasures parties. They were really fun. Really, really fun. And then there was that lingerie company with those parties, but I'm beating my brain and I cannot remember the name of the company that did those. But you know, Tupperware now, all the Tupperware they sell now has that technology or whatever that it won't turn orange. So if you can put spaghetti in any Tupperware right now, you can. You can put spaghetti in and then you can microwave it and it still won't turn it orange.
We have photos of the truck. I suggest to you that those photos are very important. We've heard Ms. Riedel talk a lot about arson, and we fought over whether Mr. Neal would be an expert in fires. I'd certainly submit to you he's worked more fires than anybody in this room, I could guarantee it. And I'd suggest to you it doesn't take a rocket scientist to look at that truck and tell that it was set on fire purposely. And I'd encourage you when you get back to deliberate in the room, all these exhibits will go back there with you. You can look at the pictures close up in person and figure that out for yourself. I put up a few maps. Like I said, I'm directionally challenged. I use my GPS for almost everything.
Undercoverware? Is that it? That sounds right. But I think it might have been Undercoverware. Does that sound right, Monica? I wish I could remember the name.
Google Maps is my best friend. I know that maybe not all of the people on this jury are familiar with every piece and part of Milan, Georgia, or Jacksonville, Georgia, or the area where the well was. And so those were done to just kind of help orient you to time and place and where these things are. And we also saw photos of Brandon, and he had no injuries. And just while we're there, so I don't forget it in my mind, the reason that's important. So during that interview, you heard Brandon tell Josh Ballard, the agent, look at these bruises on me. He said that. I would assume, or I think you can presume, you can put that together for yourself, that during that, he would have probably pointed to some area of his body. Certainly, if he lifted up his shirt and he had some giant bruise there, that's going to be documented. And I think you can put it together, that's not documented because it wasn't there. You also heard from 15 witnesses in this case. The eyewitness, Ms. Jane Williams, I think her testimony is very important. We heard from 4 experts in this case. Agent Cootie's a crime scene specialist, and she is also a specialist in blood stains and spatter. Terry Neal, we talked about him already with the fire. Dr. DeMarco, the autopsy doctor, and then Mason Cree with firearms. We heard from Lynn, Brandon's then wife. She told us about other instances that she was aware of. She told us about prior difficulties between the two parties. Donna Owens, the victim's then partner, she told us about prior difficulties. We heard from several law enforcement witnesses, several investigators, and we heard from the Boones who observed the fire, helped put it out, called 911 when they saw this man walking off from the scene. That ended up being Brandon. All right, so just to kind of, I won't go through all of them, but Jane Williams, her testimony I think is so important. She says that part of her daily routine is to kind of go to the post office there in Milan. She normally does that between 12:30 and 1. That one of the maps and evidence is her tracing her steps or her travel path from her home behind the railroad tracks up through Mount Zion. So she passed the direct opening where this workshop was, and she passed by Brandon's parked truck. She says that she had to kind of go around Brandon. He was kind of in the road in his parked truck, and that even they waved at each other. That when she saw him, that he seemed to be getting back in his truck to leave the area. And notably, she did not see another man standing there. She didn't hear anybody hollering, arguing, even though she would have had her windows up, presumably. We talked a little bit about that. You can certainly infer that it would be reasonable if there had been some giant loud altercation that she would have heard it or she would have seen it. The post office is not far at all from this area. You can certainly see it in the crime scene photographs. I think the third or fourth crime scene photo that we put in, well, the first 3 or 4 is a visual from the left side of that road, the front side of the road, the right side of the road, and in that right side photograph, you can see the post office where Miss Jane was. And she says the minute that she stepped out of her car, she heard shots. And now, why she didn't think anything of it at the time, that baffles me. I'm not sure. But she didn't. It never crossed her mind. And, we live in a small town. We like to think gun violence doesn't affect us. And maybe that's just what it is. It just didn't cross her mind because she never saw that other individual. She never saw another man. She saw Brandon Spires shooting. That was odd, but she just chalked it up to maybe he was, shooting something like an animal or something over there. But she unequivocally stated that she saw Brandon with a rifle, which turns out to be true. We know that later. So we see the body cam footage. We see some of the body cam footage. What I think is so important from that first body cam footage that you saw was just the initial coming upon that scene, the location and posturing of Joshua Fort's body. I think that speaks for itself. I think when you think of self-defense, what I want you to do when you go back in that room and you make your decision, I want you to think about how Joshua Fort's body was laying there. His back was to the road. He was pushed up in the corner of that little alcove where the sliding door was. And we heard some testimony that normally when he was working out there in his little workshop, that door was closed. And in the photographs you can tell there's just a small sliver that's open. And that's on the opposite side of where his body was. What else I think is important about that crime scene, which we see not only in the crime scene photos, but also in that body cam footage, is that you see that his bike is parked right there in front of it also. And though I can't see on the camera, maybe you have better eyesight than me, I can't see the shell casings yet before they're marked later on with the crime scene photos. But you see the roadway where those things were eventually collected from, and they're on the opposite side of the road. So when we're thinking about that self-defense claim, we're thinking about somebody's coming out at me. You're telling me that Joshua Fort, who's over there in the corner, his head's pushed up in the corner, with his back turned to the roadway, that he was progressing aggressively towards someone with his bike in the way, somebody who's in a truck and has a rifle. Make it make sense. The crime scene itself, or the body cam, we see Brandon on the roadside right after he's burned up the truck. It's not long after this murder has taken place. He looks very disheveled. He's not talking anything about this shooting. But he says Milan isn't anything but a bunch of thieves. And then he starts talking immediately about somebody stealing his firearms. But he didn't say anything about the .22 rifle. They stole his other firearms.
I'm just never ordering from Fredericks of Hollywood ever again, and I'll tell you why. I'm going to tell you why. I'm just not. I'm telling you why. The last 5 men I've dated, right? Everything's fine. Everything's going along great. We're dating, we're seeing each other, da, da, da. Every single time I put in an order for lingerie, 5 times in a row this has happened. Before the package gets to my house, the relationship is over. I think everything's going great. I placed this order for lingerie. And nope. Before I even get it, boom. No more relationships. That's it. From now on, moo-moos. Only muumuus. That's it. If I ever date again, you will know, because I will only ever wear a muumuu. Ever.
And he must mention something about wrecking his truck off camera, because I don't believe that was on the camera. Now, the crime scene, I've already kind of talked about that. It is a gruesome crime scene. I did not put those.
The bad part about that, you want to know the really bad part about that, is I can't throw that stuff away because I just spent money on it. So it reminds me. It's just a constant reminder in that drawer right there of failure. It's just full of packages that I can't throw away, but I'm never going to ever open or wear.
Photographs on these slides out of respect for the victim's family, and I didn't really put them that close to you and make you look at them up front and close because of that. But if you believe that you need to see them more closely, they'll be back there in the room with you also. Feel free to look at them. The sheer amount of blood, the sheer amount of gunshots in this case, all those casings in the street, and Agent Cootie told us they were at least 40 feet away. Those things are definitely evidence that this was not self-defense. We got to hear about the autopsy. 8 gunshot wounds, and I guess technically one of those was a graze wound. But what was interesting about Dr. DeMarco's testimony is that the entry wounds weren't just on the front of Joshua Fork's body. They were also on the back side of his legs, meaning that when we see him in the video and these crime scene photos, kind of pushed up in that corner with his back to the roadway where Brandon Spires would have been, he was shot in the back. He wasn't shot as he was progressing towards someone. That's not self-defense. There were no defensive wounds on his body, not on his hands. He was not shot at close range. If we were to believe that he was shot at close range, we would see soot or we would see stippling on the wounds. The autopsy doctor said neither of those things was present. Forensics, why did we even have to do that? You really didn't. We know that he used this gun. He said he did. We know he shot this man. But it was done at any rate. The firearm tested by the examiner was functional, and the fragment that Dr. DeMarco pulled from the right knee matched the firearm itself. And all of the other fragments were consistent also with a Savage .22 rifle, states 80. And he explained to you, and the reason I made that comment about did we even have to test that, a .22 is extremely hard to get a match on because of the way that the bullet fragments after it leaves the firearm. So at any rate, he was able to make a match. He was able to say, this one definitely came from this gun, and the other ones are consistent with being from this gun. So the evidence that we see of Brandon's guilt, he drives off and he throws away the gun in Milan. Self-defense, why are you throwing away your gun? Perfectly good gun, why are you throwing it away? He drives to Jacksonville where his truck's set on fire. The behavior in the body cam videos, the statements during the interview, I'm going to spend a little more time on that. And then we heard about the prior difficulties. We heard that Brandon tried to run Josh over. We heard that from 2 people, Donna and Lynn. We heard Lynn tell us that he had broken into this man's house before with another friend and held him up. His own mother told us about the first instance where he ever met Brandon was not long after he moved to Milan. He just barged on in the man's house and accused him of sleeping with his wife. He didn't even know the man's wife. He barely knew anybody. That's crazy. He threatened to kill him multiple times. Lynn told us that. He fired shots off at a house that he believed Josh to be in, and he fired shots off by the road. So this is the crime scene sketch, and I know we spent a lot of time on that with Agent Cootie. My pointer won't work on this screen, so, but I think you can see it pretty well. 1 through 9 there, that's where the casings were ejected. That's the middle of Mount Zion Street. You see the bike on the sidewalk, you see the storefront, and then you see that it is a recessed kind of alcove where Joshua Fork's body is. And his head is positioned to the corner, his back is to the street, and the opening for the door is just there past his feet. This seems obvious that he had been on the other side of that door, that he was called out, opened the door slightly, came out, and that's when Brandon Spires decided to gun him down. That's his own words, I gunned him down.
There actually is a 0.0000001% chance, Brent. So, not.
and I just want to show, this is State's 31. Here's the bike, here's the storefront, here's his back to us. And you'll have this back there. Feel free to look at it again. All right, Brandon's interviews. That was a wild time. There were a lot of things in those interviews, and I think they're very important. And some of you I know made notes. Some of you, I think I could read from your facial features, your facial responses could pick up on certain quotes that were made in that interview, so I just want to talk about them. In both the first interview, which was not very long, and the second interview, he talked about hiring an attorney a couple of days before this event happened. I just found that interesting. What else I found was interesting, and we talked about this in the opening, is that he only wanted to talk about the shooting after he was served with arrest warrants for malice and felony murder. Up until that point, he said nothing about a shooting. I gunned him down. I said that to you in the opening, that you would hear that come out of his mouth, and he did. In this interview, he said it multiple times, because that's what he did. He also said this girl's got to go when he was talking about Lynn. A man can only take so much. I mean, I'm worked up to the point. They F with me until I go crazy. The day of the shooting, and so what I love Agent Kraft. He did not testify in this case, but he was the other one in that interview with Agent Ballard. He had to keep rerouting Brandon back to talk about the actual day of the shooting, because all Brandon wanted to talk about was, hey, y'all need to go check out Lynn and arrest her. She's stealing my businesses. She's doing all this crazy stuff. He was telling about all the cameras and online accounts he had. And then he finally said it. He said, oh, that morning I found a video they shot at the house. So when you think about evidence of not self-defense, think about that. That was in his mind that morning. That's why he initially told them that he left to go to the shop. That's why he said this is why this shooting happened. Now, did he really find a video? No, he did not. He did not. There is no evidence that there was any kind of sex trafficking going on, no evidence that there was any kind of pornography videos going on, any of this. Multiple times he said, I pulled up. I pulled up. So when he's making up this crazy story about self-defense in this interview, and Ms. Riedel in her opening statement, that his parents lived nearby, and he just happened to be driving through there, and Joshua Fort called him out. I pulled up. You did. You pulled up to this man's workshop with your rifle. That's not self-defense. He said numerous, he said numerous times that this was a crime of passion. He didn't really know what that meant, but he liked that language. And he then said that Josh said something smart to him. And I found it very callous how he said on multiple occasions, I was scared of him, but I'm not scared now. He was a threat, but he ain't a threat now. He talked smart to me, but he's not talking now. No, he's not, because you just killed him. I found it interesting, his hyper-focus on religiousness, especially in regards to his marriage. And there always seemed to be someone else to blame. And primarily, the people that he liked to blame in this interview are Lynn and Josh. Everything was their fault. He spent a good, I'd say, 75% of that interview blaming Lynn for all of his problems. Bam, 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 bam. He said it 8 times. I found that interesting, because that's how many bullets grazed or entered the body of Joshua Fort. It was the exact number. He said that Joshua Fort threatened to kill him several times, and when Agent Ballard said, oh, he threatened you with a gun, and he said, not so much. You did not hear one single person come into this courtroom during this trial and tell you that Joshua Fort ever had a gun. I want you to think about that too. Think about a man, and Ms. Riedel, when she was questioning Mr. Fort's mother, talked about his meager circumstances, his meager, living in this workshop that he rented.
I can't figure out if it actually is Miss Riedel or if it's Miss Riddle, because they keep saying it, and I'm trying. They hit that E a little harder, I think, than like heel. They're saying Riedel, but I think they're actually saying Riedel, I think, this time. Or do you think her name is Miss Riddle? Miss Riddle is more common. So that's why I don't know, it's just been confusing me this whole trial.
Seemed like a man with a lot of guns. seem like a man who's some big drug kingpin or some big sex trafficker? I think not. There's no evidence of that. He claims that Josh beat him up the night before, but then he said, oh, it wasn't that bad. And we know that's because the night before, the real aggressor in that situation was not Josh Ford. It was Brandon Spires. He said he was wigging out and then he threw up. Since I gunned him down again. He threw out the gun, but he said he wasn't trying to hide anything. I want you to look at that picture of that well and that grate that was on top of it with all that other stuff. It seemed like he was trying to hide something to me. I should have called the police, that's what he said. And if this was self-defense, don't you think that's what he should have done? Or even if he didn't feel comfortable calling them, when they picked him up on the side of the road and he said, thank God y'all found me, seemed like the perfect opportunity to say, hey, by the way, this man threatened my life and I just had to shoot him. He didn't say any of that. Instead, he wanted to make up a bunch of lies about people stealing his firearms. Nobody stole your firearms. You threw them away. I gunned him down. The truth is the truth and the lie is the lie. He said that. I love that quote. I also love this. This was a state's exhibit, and I don't know what number it was, but it was in the truck fire. And interestingly enough, and I like this about a lot of things when you see fires, a lot of times you'll see house fires, truck fires, other kind of fires, and you'll see that Bibles survive those fires. It's always interesting to me to see what remains of that Bible. And I found it very telling that this Bible that was found in his truck was a page on honesty. And we didn't hear a lot of that come out of Brandon Spires' mouth. I just lost it, bro. He was trying to claim that it was Lynn's fault, that he did this, she was driving him crazy, yada, yada, and then he just said, she didn't make me do anything, I just lost it. That's the truth. He's tired of that witchy woman. I fell in love with a promiscuous woman, that's my big problem. He blamed his wife for sleeping with everybody he knew, I believe. His friend Joseph Dooley, where he ditched this gun, he had accused her of sleeping with him. She didn't do any of that. And I found this probably to be the most interesting and the most telling for why he came up with this wild tale during this interview. Since I talked, am I still charged with murder? What a ridiculous question. So, the law. We're going to talk about self-defense. I've talked about that a lot already. But the judge will instruct you that a defendant is not justified in threatening or using force if he provokes that threat to use it as an excuse, if he's committing a felony, or if he's the initial aggressor, unless he withdraws from the encounter and tells that to the person. Self-defense is not 8 shots. He did not need to do that. That was unnecessary. It was calculated, deliberate, and intentional. It is excessive. That is excessive force. With a scoped rifle about 40 feet away, you don't use a scoped rifle in self-defense. Maybe if you're at your own property and you have the advantage of seeing somebody coming from a while away, maybe. But what do you use a scoped rifle for? That's for hunting. And I want you to think about that when we're talking about self-defense. We're talking about him being in that roadway and being in his truck. He didn't have this rifle in his pocket. It's not easy to just whip this out in a split second and put it up on your shoulder and get ready to shoot somebody. And he shot this gun 9 times. And out of those 9, he's a very accurate shooter, 8 of them hit the the victim's body, excuse me. Think about that when you're thinking about self-defense. If you're thinking about him in that truck, and we know he'd already been sitting in the truck as if to leave, because that's what Miss Jane said. Miss Jane ain't got a reason to lie. But he went through the trouble. He had enough time to go in his truck, pull this out, put it up well enough to point it, aim it, and shoot it pretty accurately. For a man who seemed to be retreating, who did not seem to be aggressively coming at anyone. In the back. He shot this man in the back. Some of those wounds were in the front of the body, some of the entry wounds were, but some of the entry wounds were also in the back. And that's not self-defense. Joshua was in the corner. We've already talked about that. Most importantly, Joshua was an unarmed man. What were the contents of his pockets? Cigarette pack, and a keychain. That's it. These 2 items. Look like a gun to you? Are you going to mistake this for a firearm in someone's pockets?
Monica, otters hold hands when they sleep so that they don't float away from each other. So he has to buy 2. He can't just buy 1 otter. It'll float away.
Think not. Self-defense is not hiding the murder weapon in a deep well in a wooded area. Ms. Riedel is certainly right. I don't think law enforcement would have ever found this gun if he didn't tell them where it was. And that was intentional. That was for a reason. He didn't want it to be found. Until he thought, hey, if I tell them where it's at, maybe I won't have these charges on me. Burning up the truck used in the murder. Now, everybody knew that Brandon drove that truck. And you could surmise he knew he was going to be on some cameras. He was big into talking about the cameras at his house. I would assume he probably knew there were cameras at these businesses. And probably they saw him driving in this area after Joshua Fort was killed. I think you could put the dots together. He probably thought he needed to get rid of that truck. Even if he didn't have the firearm still in that truck, people knew that truck. He burned that truck so well they couldn't even run the tag on it. And you think about that when you think of a wreck and a truck being on fire. The very back of the truck, where the tag is at, is burnt slap up. They can't even read the tag. The interior of the truck, not a stitch of seat left in it. And I know we talked a lot about the ownership of the truck. Ms. Riedel's argued that. My car is parked outside. It's in my name. It's also in my husband's name. My husband has an ownership in my car. Do you think if my husband goes out there and burns my truck up that that's not arson? Absolutely is. If you go out there and you burn somebody else's truck, even if you also maybe have some ownership interest in it, that's absolutely arson. Self-defense is not words alone. The judge will instruct you in these jury charges that words alone never justify the use of deadly force, no matter how abusive or provoking.
Except for you, Monica. Monica, words alone could be deadly force if you are casting a killing spell. Don't use words to cast no killing spells.
Now the charges, malice murder just means that you cause the death of another person unlawfully and with malice aforethought. What does malice mean? It's a deliberate intention to unlawfully take the life of another. It can be implied. Essentially just means that he intended to kill this man. And how do we know he intended to kill this man? Well, there's a lot of evidence, but 8 shots certainly would suggest so. Felony murder. That means that you caused the death of another person while you were committing a felony charge. The felony, which we call the base offense in this case, is aggravated assault. An ag assault is when somebody assaults you with a deadly weapon, which is how we charged it in this case, and the judge will instruct you a firearm as normally used is a deadly weapon under the law. So assault just generally means that you've placed another person in apprehension of immediately receiving a violent injury. Joshua Fort was in fear, absolutely. He was shot multiple times. He appeared to be retreating. Like I said, he was backed into that corner door area, and he had a history of Brandon threatening and attempting violence to him. And I already talked about the firearm, so we'll move on. Arson, you knowingly damage by fire the vehicle of another without their consent. And you can certainly imply that his wife did not give him consent to burn this truck in the manner that he did. And possession of firearm during a crime just means that you have on or within your arm's reach a firearm while you're attempting another, or while you're committing or attempting another charge. And that charge being a crime against the person of another. And we have 3 of those in this case. So 5, 6, and 7 correspond to 1, 2, and 3. Counts 1, 2, and 3. So beyond a reasonable doubt, the state does have the burden to prove every case, every element beyond a reasonable doubt. The state's not required to prove it beyond all doubt. If we were, that would mean that you all had been there. And if you all had been there, you wouldn't be sitting in this box, you'd be sitting in that one. So when Ms. Riedel was talking about tipping the scales and the scales have to be all the way down, that's not quite true. Because you can have some doubt. You don't have to, it doesn't have to be beyond all doubt or to a mathematical certainty. It's just a reasonable doubt of a fair-minded, impartial juror honestly seeking the truth based on common sense and reason. I like to tell jury people, don't check your common sense at the door. You can certainly use your life experiences when you're making your decision back there in that room. And I presume that you're all reasonable people. And you know what that means. It's a pretty simple construct. I normally use the puzzle analogy, and if you've watched any sort of crime shows, you may have already heard it, and I do apologize for repeating it. But normally when I think about reasonable doubt, I think of a jigsaw puzzle. You have the box. Maybe it's a beach scene. You've got your sand, you've got the ocean, you've got a sailboat out there and some clouds. And so maybe you don't have every piece of the puzzle. Maybe you're missing a few parts of the cloud or a few parts of the sail. But when you put it all together, you can tell still what the big picture is. And I suggest to you in this case, you have all the pieces. You have every piece. You can see the big picture. There's, like I said, an opening. There's not much more you can ask for in a criminal case as far as evidence goes. I want to end with Joshua Fort, the victim in this case. Now, when we came into this courtroom, before you were even selected to sit in these nice chairs, we said the Pledge of Allegiance. And I bet many of you probably haven't said the Pledge of Allegiance since school. It's not something you probably get up and do every day. But the last phrase that we say in the pledge is liberty and justice for all. For all includes Joshua Fort. Did he have some struggles with substance abuse and some alcohol? Maybe so. That doesn't mean that he deserved to be shot 8 times in what clearly was not self-defense. He is protected under the law just like you and just like me. I'd ask you to return a guilty verdict on each one of these counts. When you go back in that room, you'll get a jury verdict form that looks like this.
Monica is very smart, and here's how I know. I would be irritated speaking to her if she wasn't, and I'm never ever irritated with Monica. Never, never.
There'll be a box for each count. I want to just talk to you real quick about the first 2. It says we find the defendant guilty of malice murder, or the defendant guilty of lesser included voluntary manslaughter, or not guilty of malice murder. Counts 1 and 2 have these alternate lesser included charges on there. And the judge is going to tell you just what voluntary manslaughter means. So I'm not going to go through all that. But we would ask you to check this box. Guilty of malice murder, guilty of felony murder, guilty of aggravated assault, guilty of arson in the first degree, guilty of possession of firearm during the commission of a felony. Thank you.
Thank you, Ms. Pitts. Ladies and gentlemen of the jury, you are now considering the case of the State of Georgia versus Brandon Daniel Spires. The grand jury of this county has indicted Mr. Spires with the offenses of malice murder, felony murder, aggravated assault, arson in the first degree, and 3 counts of possession of a firearm during the commission of a felony. The indictment states the exact charges and are as follows. The grand jury in open court returned a true bill of indictment dated March 20th, 2023 against Brandon.
Okay, we just heard the charges. I'm going to bump it forward a bit. I thought I cut out the whole jury instruction part, but I see I didn't. I thought I did, but, you know. So we're just going to wait for the jury to get up and go. See how long he talks? Jury, okay, there we go. I'm going to back it up just a tad. There.
Left to be published in open court. Now, we have 2 alternates here. Since the law only permits 12 to deliberate the case at the time, the bailiff will seat the 2 alternates in a separate room to remain available if needed. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment, the verdict form, and any evidence which has been admitted in the case. Thank you, and go now as directed by the bailiff.
No. Did you see those 2 people come forward? They weren't jury members. They couldn't have been. That's not right. Mistrial.
You be seated. Any objections to the charge as given, Ms. Freedom? Ms. Pitts?
No, Your Honor.
All right, very well. Who's going to take the responsibility for gathering up all the exhibits? I'll let the attorneys do that. I have the verdict form and the indictment here.
Okay.
I'll place it here on the bench.
And Judge, I did pull out the 2 search warrants. Typically, those do not go back to the same potential and because of the continuing witness rule, I don't care if they get them, but it's been my experience that they don't typically go back to the jury.
I do not want them to do that.
Very well, so ordered. Make sure they are pulled out of the stack. Anything else?
And then we typically don't send them.
Yeah, not the gun either. I know the agent said it was cleared, but it's gonna stay right where it's at.
Be right back.
I'm giving this to you to be filed in. Yes.
My client is requesting that these go back to the jury.
What's that? The search warrants? All right, so ordered. That will me.
You can include all of the,
What you got, Judge?
What's that?
What have you got me for?
The jury charge.
just to make sure.
All right, we are in recess.
Your table's a little cleaner than mine.
Spires is coming in now. All right, to get them back on the record, we have all parties present. The bailiff has informed me that the jury has announced to the bailiff that they have a verdict. Of note for the record, we have all parties present, including Mr. Spires, properly constituted court. All right, Captain, bring in the jury, or Sheriff, bring them.
We can't do them all. I'm trying to get the video table back.
Oh, okay, hold on just a second. Yes, sir.
Here, we can sit down for a minute. That's definitely not a good sign. That's not a good sign, because they usually deliberate.
Miss Sophie's trying to round them up, Judge. Sorry. Give us
Should we wait?
a few more minutes, please.
Okay,
Sorry.
You can be seated until, everybody did, okay, good. Do you usually?
We're about to hear from him soon. I guarantee you, none of you are going to like it. So when he starts talking, if you want to go make a sandwich or go pet your cat or something, you're not going to find it enjoyable to listen to him at all. And as it doesn't go on too long. It's just so awful that it feels like it takes forever. And unfortunately, I should have kept it in. His mom, I think, gives a victim impact statement, and his mom blames herself. She's like, I turned my back on him too many times when he was struggling with mental issues, when he was struggling with drugs. I just got fed up with him, and I couldn't take him anymore, so I just turned my back on him too many times recently. So this is all my fault. So I should let that in and took his out. But you're about to hear him, and it's unpleasant.
Judge, I believe everybody's here and accounted for. Thank you.
All right, back on the record. Now that everyone is all assembled, let me make just a few general announcements here before I bring in the jury. This is more or less just to protect the record. The court has been advised by the bailiff that the jury has reached a verdict. I know these issues are very emotional, and I understand that. I'll make sure everyone understands. However, emotional outbursts either way will not be tolerated. Thank you for your cooperation. And with that, all rise, please, and bring in the jury.
Also, when he starts testifying, it would be perfectly natural if a lot of you just freaking mute it. If you do, I'm going to type the word thumbs up because I'm not searching for the freaking icon. I'm blind, okay? And that's going to tell you that his testimony is over and you can unmute because it's unpleasant.
All right, please be seated. I'll note for the record that we have, make sure I've got the two alternates. They're right here. They're back there? All right. Note for the record that all jurors are back in their places in the jury box. We have a properly constituted court. Ladies and gentlemen of the jury, I presume you elected Mr. LaFavor as your foreman, is that correct? It's always the one carrying the form. So, Mr. LaFavor, you have been selected as the foreperson, is that correct? Yes. Please stand, Mr. LaFavor. Have you and your fellow jurors reached a verdict?
Yes, sir.
Was it unanimous?
Yes, sir.
As to all counts?
Yes, sir.
Has the verdict been filled in with your decision by you and signed and dated by you as the foreperson?
Yes, sir.
Please hand the verdict form to the bailiff, please, sir. You can be seated, Mr. LaFavor. All right, I'll state for the record that I have in my possession the jury verdict form. A decision has been indicated on all 7 counts, and it has been signed and dated by Mr. LaFavor as the foreperson.
Listen, Josh didn't hear, and I love him too much. Josh, you're about to hear from him, the murderer. If you decide to mute it because you can't handle it, it's just unpleasant all around. I'm going to type the word thumbs up when he's done so that you can unmute it again. It's up to you, though. I would go make a sandwich.
Is that correct, Mr. LaFavor?
Yes, sir.
All right, Mr. Spires, now time to publish the verdict. Please stand, Mr. Spires. As to count 1, the verdict form indicates, we, the jury, find the defendant guilty of malice murder. Count 2, the form indicates, we, the jury, find the defendant guilty of felony murder. Count 3, we, the jury, find the defendant guilty of aggravated assault. Count 4, we, the jury, find the defendant guilty of arson in the first degree. Count 5, the form indicates, we, the jury, find the defendant guilty of possession of a firearm during the commission of a felony. Count 6, the form indicates, we, the jury, find the defendant guilty of possession of a firearm during the commission of a felony. Count 7, the form indicates, we, the jury, find the defendant guilty of possession of a firearm during the commission of a felony. Ms. Riedel, anything you want to ask for at this time?
Yes, I'd like to poll the jury, please, Your Honor.
All right, very well. Ladies, and you can have a seat now, Mr. Spires and Ms. Riedel. Ladies and gentlemen of the jury, as is...
Oh, hell no. I didn't know they were going to pull the jury. I didn't hear this part. Hell no, we're not going to listen to this. All right, so we're at 2-8.
Was it freely involved? They bother you any longer, you notify the sheriff's office and they'll take care of it. Now, you are free to leave. Are we ready to proceed with sentencing?
Yes, Your Honor.
All right, you're welcome to stay. If you wish to stay, you can go out here and have a seat, but if you want to leave, then please go on out the back door, drop your badge off with the clerk.
Ms. Mildred.
Oh, Ms. Mildred can take them up right now. And you have the checks? You have your pay? Very good. All right, let's take just a few minutes here and kind of reset the deck and,
I get the evidence and everything from back there too?
I'm sorry?
Do you want to get the evidence and everything from back there too and put it back here?
Absolutely, absolutely. All right, so we'll take a 10-minute recess while we're resetting the deck. All right, let's get back on the record. I'll note for the record that all parties are present, including Mr. Spires, seated at the council table with his attorney, have a properly constituted court. The verdict from the jury has now been published and accepted by the court, and it is now time to proceed into sentencing. Is the state ready?
Yes, Your Honor.
Ms. Riedel, the defendant, ready?
Brandon, will you raise your right hand?
Yes, ma'am.
Do you swear or affirm anything that you're saying to this court is the truth?
Yes, ma'am.
Okay, state your name, please.
Brandon Spires.
I'm going to move out of your way, and I'm going to let you say what you want to say.
I want to say sorry, but sorry, don't do it. Sorry, just don't cut it. I know it don't. I know I wish I could bring your son back. I see him every day in my dreams. I'm so sorry. I am so sorry. I'm so sorry to his kids. I'm so sorry to you, man. Oh, yo, I'm sorry, Miss Scott. I got a piece of paper with your name on it from some booking information. Your Josh had his open record, and I pray for you every night. I was struggling bad with my mental health, and I didn't have no medicine. And I didn't have nobody to help me. I'm sorry. I'm so sorry. Please, one day, if you can, forgive me. Please, ma'am. Kids, I'm so sorry. To his ex-wife, I'm so sorry. I'm so sorry to you, sir. I am. I swear I was a coward. And I'm very, very sorry. There's not a day that goes by that I don't see Josh's face in my dreams. I lead a Bible study over in Telfair County, December the 29th, 2022, the day after your son died. I hit my knees and I said, God, please help me. Please, I've killed a man. And I invited God into my heart, and the process of sanctification began to start. But I'm going to tell you this, there's nothing I could ever do. I'm not the man I am now. It's not the man I was December 28, 2002. I truly chased the Lord with my whole heart. But I wasn't living it then. Addiction robbed y'all, and I robbed y'all of y'all's child, and addiction robbed me of everything. I had full intentions on if I walked out of this courtroom today, I was going to try the piece of land that I had in trailer, and I was going to start a ministry in your son's name called Josh's Place to honor his name, because I'm so sorry. I am so sorry, and I can't say it enough, but I don't know what to say other than that, ma'am. Please forgive me one day, please. Please. That's all I got.
All right, Ms. Riedel, anything else with the defendant?
No, sir, that's all we have.
You ready to proceed into argument at this time?
Yes, Your Honor.
I
Yes.
typically allow the state to open and close. Do you reserve close, or you want to go first and last?
I'll go last.
All right, Ms. Riedel, you ready?
Yes,
And this will be your recommendation.
Oh, okay. Guys, we're going to hear from the defense lawyer, just bullshit. Then we're going to hear from the prosecutor. Oh, it's so good. Oh, she's so good.
To the court for the sentence, is that correct?
Yes, sir.
All right, go ahead.
Your Honor, my understanding, and I think that I'm right on this, that the felony murder vacates with the malice murder. And if I'm wrong, you can speak up anytime, Keeley, but I'm pretty sure that I'm right about this. And the ag assault merges into the felony murder, but the felony murder vacates because of the malice murder. So I think that what we have on those 3 counts is 1 count of malice murder. And then as to the arson, that is just the sentencing range is 1 to 20. And then on the possession of a firearm during the commission of a crime, they're all going to merge into 1, and that is a mandatory plus 5. So, Your Honor, what I'm asking the court to do, and I think, my heart goes out to the family but there is nothing that you can do in this courtroom that would ever bring Joshua Fort back.
Zach, hello there.
I mean, we can't do
You're coming up here soon, right, Zach? Coming up to Pennsylvania?
that. If we could, we would all do that. But as you heard from Mr. Spires and his witnesses, he struggled greatly with mental health issues. He had just gotten out of a mental health facility 2 weeks prior to this happening. And I mean, you heard him in his interview saying, I need my mental health meds. He's struggled with that for a long time. And what I'm asking,
Terry, you're close. You're this close. What happens next is all for Bobby. Bobby's gonna love it.
the court to do is that, I mean, it's a mandatory life sentence. So there's not a whole lot of wiggle room in this, but I'm asking for life with the possibility of parole. And, I mean, there is, and that's what I'm asking the court for. And as far as the arson, I'm asking that the court have any sentence of that to run concurrent with the life sentence with possibility.
Ms. Pitts?
Yes, Your Honor.
Zach, we have this lovely castle on King Street you can stay at.
Judge, I am going to ask the court to sentence Mr. Spires to life without the possibility of parole on the malice murder charge. I think the evidence that's been presented in this courtroom speaks to the violent and unnecessary nature of what took place. I'm also asking this court to sentence Mr. Spires to 20 years on the arson count. And this court is mandated to sentence him to 5 years of consecutive time to any other count on the possession of firearm during the commission of a crime. I do agree with Ms. Riedel, just put that on the record, that the firearm counts would merge together as a matter of law, and that the ag assault would merge into the felony murder, and the felony murder would be vacated by law because of the sentence on the malice murder. I am asking for the maximum sentence in this case because I believe it is well-deserved. Brandon Spires has shown no remorse in this case until we got to this part of the sentencing. He did not once say it in his interviews. He has not once said it to anyone else. He brought us here to have a trial in this case unnecessarily, and I know it is his right, but Judge, I can't help but think that if he was so sorry that he did this, that he would not have put us to trial. And what he did when he made this family sit in here and listen to these horrible facts is just really unexcusable. They had to hear about how he was shot 8 times on the side of the road where he lay bleeding until someone discovered him and called 911. And I hate that they had to hear that, because I genuinely don't think that they knew how many times he had been shot until I met with them in preparation for this trial. And out of respect for them, I tried to shield them as much as I could from pictures of this crime scene because it is gruesome. It is one of the worst crime scenes I've ever seen. The autopsy photos are also equally terrible because there are so many holes in that man's body. And I can't imagine, I don't know if they ever saw his body when it came back from the crime lab. I hope to God they didn't. That is a horrible thing. I can't imagine for a parent to have to hear a brother and children. I believe that anything less than that would just be, it wouldn't be justice in this case. And I find it really difficult to listen to Mr. Spires' statement here in this courtroom, particularly given that up until this trial week, he wouldn't even admit that he's the one that shot him, other than in that interview.
Several times.
Oh, no, sir, it's my turn. And Judge, there is just simply, there's simply no reason for it. And if any case that I've ever tried or this court has ever seen warrants the sentence of the maximum, it's this one. And that's what I'm asking. And I ask that on behalf of his family, and I ask that on behalf of him as well. And that's all the state has.
A couple of things I want to get on the record. Not much, but just a few thoughts, comments. As both attorneys have said, and most of the witnesses here and during the sentencing hearing seem to have their minds around the idea that the court, I started to say, has little discretion, very little discretion on the malice murder charge. Everybody knows that. It doesn't make it any easier. And I will agree with both attorneys that there's really only 3 of these 7 counts that the court is allowed to sentence on. The court does agree that the felony murder count 2 will be vacated and that count 3, the aggravated assault, as both attorneys have suggested and recommended, and I agree, they do merge, as do the 5, 6, and 7. Or correctly, let's say that 6 and 7 merge with 5. So there's not a whole lot of boxes I can check here. The court has some discretion on a couple of these. And I've tried a lot of murder cases. I've tried murder cases in this very courtroom and in other counties, and I have, on occasion, found some reason that I could articulate for the slight bit of wiggle room that the court does have on the malice murder charge of count 1. And just to get right to the point, folks, let me say I have no illusions. I can't remember who just said it. I think it was Ms. Pitts just said it, that there's nothing I can do or say that's going to make any of this any better for anybody sitting in this room. And I know that. And I'm not an overly emotional guy, but I will just let you know there's just not much I can do today, except pull my judge hat down real tight and articulate some reason for what I do. I don't feel it's my place or the court's place or appropriate, Mr. Spires, for me to just sit up here and throw a bunch of rocks at you. Here we are. It's been a long journey, 3 years, over 3 years since the indictment was filed. And on the malice murder charge, Mr. Spires, the sentence of the court will be as follows. Life, of course, is the sentence. I do not find any reason to show any mercy, Mr. Spires. I am going to sentence you to life without the possibility of parole. Of course, as already stated, count 2 will be vacated. 3 is merged with 1 and 2. On the arson, count 4. The court does have some discretion on that. As Ms. Riedel said, this is a 1 to 20 range. And I have, on occasion, found other reasons to sentence people to cases with the possibility of parole or some sort of concurrent sentence, but not here, Mr. Spires. The sentence of the court on count 4, arson, will be 20 years to serve consecutive to count 1. And on count 5, by statute, I have no discretion. The sentence of the court is +5 or an additional 5 years to serve consecutive to counts 1 and 2. Counts 6 and 7 are merged. Mr. Spires, the court does advise you, you have a period of 4 years to file a habeas corpus petition from the date these sentences become final, 30 days to file a notice of appeal or a motion for new trial. If you have any questions about that, you'll need to consult with Ms. Riedel for any additional post-judgment relief. That will be the judgment of the court. Mr. Spires, you are remanded to the custody of the sheriff for begin execution of your sentence.
Yes, sir, Your Honor.
Judge, just to perfect the record.
Yes.
I believe earlier you said that count 5 would be consecutive to count 1 and 2. Would it be true that it would be count 1 and 4, the arson count?
What did I say? I said 1 and 2?
Yes.
Obviously, yes, incorrect. 1 and 4. Thank you. All right, that concludes this proceedings. You are all excused.
Life plus
You got all that?
25 with no possibility of parole. That's what we have not seen that in a while. We've seen 15, 20, 40, but they all had possibilities of parole. This guy will never, ever, 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 ever step foot. In Georgia, life without possibility of parole means life without possibility of parole. That's exactly what it means. So he has 2 options now. He has his habeas. He has 4 years to do that. He has appeals. I think he has about 30 days or something like that to start the appeals process, right? There are extraordinary circumstances. Nothing is coming to my head right now, but there are a very, very small set of extraordinary circumstances that the life without possibility of parole can get reversed outside of the habeas, outside of the appeals, but it won't happen to him. He's just there forever and he has no chance of getting out, no matter what he does. No matter how good he is, no matter how bad he is, nothing. He's there forever. Which is not, yeah, Bobby, I knew you would really like that. But it's just so weird. I mean, I agree. I 100% agree, but we've seen much worse cases get like 40 years and not life. He burnt his own truck and got 20 years for that. But anyway, I liked it at 1.25 speed so that we can get it done in 2 days. If you guys have issues with that, let me know, because I'm going to keep doing that in the future. Anyway, thank you so much for coming out to see this trial with me. I appreciate it. No stream tomorrow morning, just a stream tomorrow night. Yeah, I work tomorrow morning anyway. So, I will see you all tomorrow night. Behave. All right? Thanks for coming out, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed